covered bonds in the United States, although we'll also talk to some extent about covered bonds in Europe. I'm going to cover the basics of covered bonds, what they are and how they're used. The covered pool isolation, which is a key feature of covered bonds. The securities law considerations with covered bonds. Issuance activity in the United States over the last few years, and kind of some remarkable issuance by Canadian banks in Europe in April and May of this year. I'll spend a few minutes on Canadian and European regulatory developments that affect the issuance of covered bonds. We'll talk about the recent US market developments and trends. And if we have time, we'll spend a few minutes on issuance of covered bonds by US banks in the past and proposed US legislation for covered bonds. So with that, I would turn to slide 3, I guess. So covered bonds are basically a form of senior debt issued by a regulated financial institution. However, they're a form of senior debt that's not subject to bail-in in those jurisdictions where there is a bail-in regime. That includes Canada. So Canadian covered bonds are exempt from the bail-in regime in Canada. Covered bonds are secured by a pool of financial assets, typically residential mortgage loans, but it may be public sector obligations in some Scandinavian countries. It's ship loans, and it may also be commercial mortgage loans. The key feature of covered bonds is that they're protected from acceleration in the event of the insolvency of the issuer, either by statute, which is the case in most jurisdictions, or by the issuing structure. And the using an issuing structure, a legal structure somewhat akin to securitization, has been the feature in a number of jurisdictions as a starting point for issuing covered bonds that was later blessed by a statutory scheme. Collateral is isolated from insolvency, the insolvency estate of the issuer, and the collateral pays the bonds as scheduled through maturity in the event that the issuer of the bonds becomes insolvent. That's a key difference from the issuance of secured debt, and it's also a key difference from the issuance of ABS. The issuing bank here is primarily liable on the bonds, and it's only if the issuing bank becomes insolvent that we turn to the collateral pool for payments on the bonds. The collateral pool is a dynamic pool, meaning it's refreshed every month. So as loans pay off, new loans are added. And if loans default, they're taken out of the pool and new loans are added. So each month the pool is refreshed and it's full of up-to-date bonds that are current and up-to-date. Covered bonds are typically issued with bullet maturities, most often with fixed rates, but also with floating rates. The payment liabilities for the covered bonds remain on the balance sheet of the originator. So unlike, for example, a securitization that's done off balance sheet where the liabilities are off the balance sheet of the originating entity. With covered bonds, the issuing bank on its balance sheet will show the liabilities for the covered bonds. Most countries have statutes enabling covered bonds. There's some 30-odd countries now who have covered bond statutes. And in many jurisdictions, there's a very strong implicit government support for covered bonds. You can see it most prominently in Germany. The German government has provided very strong support for the covered bond issuers in Germany. And despite a number of problems in the German banking system during the last financial crisis and the insolvency of some of the covered bond issuers, the German government continued to operate those banks and to support the covered bonds. And I'll come to the reason for that in a few minutes. Next slide, please. So the benefits to the issuing bank for issuing covered bonds are, one, that it diversifies their funding base. The purchasers, investors in covered bonds are a different group of investors from investors in senior debt or investors in ABS. Investors in covered bonds are typically central banks, other banks, and to some extent, investment funds. Covered bonds tend to be issued with a coupon lower than a coupon for the bank's senior debt, as you would expect from a secured issuance. Covered bonds have been a critical funding source in Europe, in particularly during the sovereign debt crisis. And the market was functional throughout the crisis and provided banks with liquidity in a very important time in the market. One of the features of covered bonds that's very attractive is that because the assets remain on the balance sheet of the issuing bank, the bank is able to make modifications to, for example, residential mortgage loans in the covered pool to accommodate borrowers under residential mortgage loans who are having difficulties without disrupting the covered bonds. A mortgage loan can be removed from the pool and replaced with another mortgage loan. And once that mortgage loan becomes current again, it can be put back in the covered pool. Covered bonds tend to bring mortgage finance out of what we call the shadow banking world, that is, issuance by trusts or other off-balance sheet entities. And just a note here that in the event that we could adopt U.S. legislation for covered bonds, it would level the playing field in the U.S. for U.S. banks, because foreign banks now are the only issuers of covered bonds into the U.S. Without U.S. legislation, U.S. banks are unable to issue bonds in this market. So I'm a heavy promoter of adoption of legislation for U.S. banks here. Next slide, please. Covered bond investors, I think I've talked about to some extent already. These are investors who typically buy sovereign debt or agency debt. Some of these investors buy Fannie and Freddie debt, although the Fannie and Freddie debt outstanding has been shrinking with the recent FHFA actions. They typically don't buy senior bank debt. They don't buy CMBS or AMBS or RMBS. These investors see covered bonds as having a similar risk profile to sovereign debt. To attract these investors, it's really helpful if you have statutory covered bonds. They do buy covered bonds out of legal structures, ABS-like structures. Now, we'll come to that in a moment. But there's a strong preference for statutory covered bonds. Predominantly, as I said before, the investors are banks, central banks, investment funds, and insurance companies. Often you'll see that the distribution of bonds in an offering is 70% banks and central banks. In Europe, this is a $3 trillion market. And the U.S. investor base, while small, has been consistently responsive to U.S. dollar covered bond offerings. Often, U.S. investors are 50% of a US dollar covered bond offering. Next slide, please. So benefits to investors. First, these are high quality covered bonds. Many of them, most of them, I would say, are rated AAA. There has never been a default on a covered bond to date, knock on wood. In Europe, covered bonds get favorable capital treatment for bank investors. So it's a lower capital charge. Plus, covered bonds avoid any bail-in risk under jurisdictions that have a bail-in regime. They typically have a higher yield than sovereign debt. So they're viewed as having a similar risk profile with a higher yield, which makes them attractive. They tend to help diversify an investment in sovereign or agency debt. They have excellent liquidity in the secondary market. The issuance of covered bonds in those jurisdictions with a covered bond statute is regulated by statute. Covered bonds tend to be more investor friendly than RMBS or CMBS. It's a much simpler analysis from an investor's point of view. The analysis is much more like the analysis of senior debt from these financial institutions. This is not an originate to sell model. So these assets are not going off balance sheet. They remain on the balance sheet of the issuing bank, and the bank accordingly has 100% skin in the game. If one of the assets in the pool defaults, the bank's responsible for replacing that asset with a good asset. And with covered bonds with a fixed maturity date, they don't show the negative convexity that you see in RMBS or CMBS. There's no prepayment risk. That's, as I said early on, the very attractive feature of covered bonds is they're not accelerated in the event of the insolvency of the issuing bank. They're expected to pay in full on their maturity date. Next slide, please. Let's just take a moment here to talk about covered bonds versus unsecured senior debt. Covered bonds typically often achieve a higher rating than the issuer's unsecured bonds because they're secured. Because they have a higher rating and because they're secured, the coupon on the bonds is lower typically than the coupon on senior bonds. And they tend to have lower volatility. The assets are generally limited to mortgage loans, either residential or commercial or public sector assets. And a single cover pool will support all of the covered bonds that are outstanding. I'll come back to that in a moment. With respect to maintenance, the maintenance efforts for covered bonds is typically higher than it would be for senior bonds. There's a monthly investor report that's done. There's an asset coverage test run monthly. There's assets being moved into the pool because assets are paying down, most typically. And occasionally because assets default, they're being replaced. In terms of size, typically covered bonds are issued in benchmark sizes, $1 billion and up. Next slide, please. Comparing covered bonds to asset-backed securities, as I said, the obligor in the bond is the issuing bank. It's not a trust. So all of the assets of the issuing bank are available to pay the obligation on the bond. whereas in ABS, only the assets that are in the vehicle are available to pay the bonds that are issued by the special purpose vehicle. The assets for covered bonds are generally limited by statute in those jurisdictions that have a statute. Whereas in ABS, there's no restriction on the type of underlying assets. You can have a great variety of different kinds of assets. And the assets that are eligible for securitization are defined in the securitization. Whereas for covered bonds, the assets that are eligible are defined by the statute. In terms of recourse, for ABS, you only have recourse to the assets of the issuing trust. Whereas for covered bonds, you have full recourse to the issuing bank. And if the issuing bank is unable to pay on the bond because it becomes insolvent, then you have recourse, to a cover pool of assets. And that cover pool has been refreshed up until the month in which the bank becomes insolvent. The regulation for cover bonds tends to be stronger, more comprehensive than that for asset-backed securities. And in particular, because the issuing entity is a financial institution that's subject to regulation in its home jurisdiction as a financial institution. We'll turn to slide 8, please. So as I said, in most jurisdictions that issue covered bonds, we have legislation. Under the legislation, investors in the covered bonds are granted some special privileges in the event of the insolvency of the issuing bank. Those privileges result in the separation of the covered bond pool from the insolvency estate of the issuing bank. And the covered bond pool is administered separately from the insolvency proceeding of the bank. And collections on the assets in the covered pool are used to pay the bonds through their maturity date. In Germany, in Sweden, in Finland, the regulation separates assets on the balance sheet of the issuing bank. In some other jurisdictions, assets are separated from the issuing bank by transferring the assets into a separate entity. That's common it's done in the UK, it's done in Canada, it's done in Australia, New Zealand. And those are the jurisdictions that started out with covered bond issuance through ABS type structures rather than through statute. And the statutes, when they were adopted, blessed that ABS type structure. In 2006, we used a slightly different structure than you're going to see for 2 U.S. banks that issued covered bonds. We used a slightly different structure because the FDIC in the United States has some unique different powers than in Europe. So we needed a different structure here. Both Washington Mutual and Bank of America used this different structure to issue covered bonds, issuing nearly $20 billion in covered bonds in 2006 through 2008. Next slide, please. We talk a moment about covered bond architectures. There are 2 types of covered bond issuance structures. There's the direct issuance structure and the segregated issuance structure. So on the left in this chart, you will see the direct issuance structure. And this is common in Germany, Denmark, and in other countries where there's a covered bond statute and ABS type structures were not used to start the market. In a direct issuance structure, the collateral pool remains with the bank and is ring-fenced at the bank. And in the event of the insolvency of the bank, then those ring-fenced assets are separated from the bank. The segregated issuance architecture on the right is what was used to start the market in the UK and in Canada and in New Zealand and in Australia, and also I think in the Netherlands. So in this structure, the issuing bank will transfer the cover pool to a separate entity, who's usually called the guarantor. And the guarantor will guarantee bonds issued by the bank, and it will secure that guarantee by the pool of assets that have been transferred to it. In the event that the financial institution becomes insolvent, the assets have already been separated from the issuing bank and will be administered to continue paying the covered bonds through their maturity date. Next slide, please. So we'll focus for a moment on the Canadian covered bond architecture. And as you can see, this is what I call the segregated issuance structure on the previous slide. Because covered bonds use a single collateral pool to support all of the covered bonds issued, the collateral pools tend to get fairly large. As an example, you can obtain a copy of the Form 10Ds that are filed by RBC, for example, or by Bank of Nova Scotia with the SEC. They're available off the SEC website. These forms contain the monthly investor report. The forms are also available off the bank's own websites, if you're interested. If you look at the RBC monthly investor report, the most recent one will show you that the cover pool held by the guarantor is just about $100 billion of residential mortgage loans. This is 500,000 mortgage loans in total. So it's a very large pool. So that's the basics of covered bonds. If there are any questions, please just enter them in the chat section. I'll be happy to try to address them. I want to turn now for a moment just to Washington Mutual and Bank of America, because they illustrate, particularly Washington Mutual illustrates the value of the segregation of the cover pool. So Washington Mutual issued its first series of covered bonds in Europe in 2006. Bank of America followed very quickly with a covered bond issuance in 2007. Both those programs were curtailed by the financial crisis, and in WAMU's case, by WAMU's insolvency. We did not have a statute governing the issuance of covered bonds in the United States. So the structure that was used to emulate a statutory covered bonds was an ABS-like structure where the assets were moved away from the issuing bank into a separate trust. The structure that was used in the United States, as I said, was a little different. It was very expensive at the time, and it would be even more expensive to use it today. So because of that, it's very unlikely that a U.S. bank would use this structure today, although it could be used. And Washington Mutual in particular provides an example of the benefits of covered bonds to covered bond investors. When Washington Mutual became insolvent, it was taken over by the FDIC. The FDIC transferred the covered bonds that were outstanding and the collateral pool to JP Morgan. JP Morgan assumed the obligation of the outstanding covered bonds. The ratings on those covered bonds instantly went up. And I forget when it was, just last year or the year before, where the last outstanding covered bonds were paid off. Washington Mutual senior bondholders, on the other hand, received pennies on the dollar. So the value of the covered bonds is really illustrated by what happened with Walmart. Let's turn for a moment to the securities law considerations for the issuance of covered bonds. Most covered bonds in the U.S. have been issued on a private placement basis. So issued either under Section 4A2 or offered under a 144A program for resales under 144A to qualified institutional buyers. Sometimes we see joint Reg S 144A programs where some of the offering is in the U.S. under 144A and some of it offshore under Reg S. You could also do an offering under 3A2 where a bank has, a non-U.S. bank has a U.S. branch where the branch might guarantee the offering. I've not seen an offering like that to date, but that's a possibility. And finally, an SEC registered offering that is a public offering without any restrictions. Turning to slide 15, Section 4A2 applies to transactions by an issuer not involving any public offering. Typically, these offerings would sell to accredited investors and to qualified institutional buyers. Next slide. Rule 144A provides us with a non-exclusive safe harbor from the registration requirements of the 33 Act for resales of securities only to qualified institutional buyers. This is a very common exemption for private placements. And the liquidity of the market is such that today there's very little difference in pricing between 144A offerings and SEC registered offerings. Rule 144A recognizes that not all not all investors are in need of the protections of the prospectus provisions of the 33 Act. The rule applies to securities that are not listed on a U.S. securities exchange or on an interdealer quotation system. And a reseller may rely on any applicable exemption, not just 144A. If an investor wants to resell, they can resell under Reg S, for example, or under Rule 144, in addition to 144A. Next slide, please. Section 3A2 applies to offerings by banks in the United States. Banks are viewed as being so regulated that the additional regulation of the Securities Act is not necessary to protect bank investors. Section 3A2, however, also provides an exemption for offerings by branches and agencies of foreign banks. Next slide, please. So under Section 3A2, an issuer relying on that exemption must meet both of the following requirements. It must be a national bank or any institution supervised by a state banking commission or a similar authority. And its business must be substantially confined to banking. So examples of entities that don't qualify would include bank holding companies, finance companies, investment banks, foreign banks, and fintech companies. But with respect to foreign banks, note again, the U.S. branch or agency of a foreign bank does qualify if it's issuing securities in the U.S. for reliance on Section 382. Next slide, please. In a noteworthy development in 2012, RBC obtained a no action letter from the SEC staff, permitting RBC to file a registration statement for its covered bond program. So this was the first SEC registration of a covered bond program. Bank of Nova Scotia and Bank of Montreal quickly followed this lead by filing their own requests for no action letters and filing their own registration statements. Bank of Montreal withdrew its registration statement filing prior to effectiveness for the reasons that we're going to come to in a moment. Between 2012 and 2016, RBC and BNS issued nearly $21 billion in covered bonds in SEC registered format, reaching a much broader investment base than they could reach through their Rule 144A offering. Because Rule 144A offerings are restricted securities, many investors have a limited capacity to invest in restricted securities. So having SEC registered covered bonds, RBC and BNS were able to reach many more investors and to reach investors who could buy a larger amount of the securities. In 2014, however, after the adoption of regulation of the amendments to Regulation AB, the SEC staff took the position that the loan level disclosure requirements of Reg AB applied to SEC registered covered bonds. Next slide, please. When these disclosure requirements came into effect in late 2016, RBC and BNS ceased offering registered covered bonds. In the 4 years since, RBC and BNS have only offered each of them 2 series of US dollar covered bonds under Rule 144A. So their issuance activity dropped off quite dramatically. It's also noteworthy that since the loan level disclosure rules came into effect for SEC registered offerings, no SEC registered RMBS has been issued. So the loan level disclosure requirements are burdensome not only to covered bond issuers, but also for securitizations. Next slide, please. There are back up one slide for just a moment, please. Good, thank you. So I want to talk just for a moment about the possible considerations under the Investment Company Act of 1940. So depending on the issuing structure, there may be an Investment Company Act consideration. So under US law, an investment company is subject to special, somewhat separate, extensive registration requirements. And it's not a regulatory regime that most issuers want to be a part of. Foreign banks generally are exempt from being an investment company under Rule 3A6. Now, Rule 386 does not exempt holding companies, and it does not exempt non-bank subsidiaries of a bank. But foreign banks would be exempt from the registration requirements under the Investment Company Act pursuant to Rule 386. But note that Rule 386 does not exempt a separate covered bond issue. So that separate entity in the Canadian structure, for example, that we move all the mortgage loans into is not exempt from covered bond registration under the investment company. We need to look for another exemption other than Rule 386. A finance subsidiary might be exempt under Rule 385. And some other exemptions that may be relied upon would be if covered bonds are sold only to qualified purchasers. Typically, covered bond issuers are relying on Section 385, which is a section, or Rule 387. But may also, in some cases, if sales are made only to qualified purchasers, it's possible they might rely on Section 3C7. Turning to the next slide. Somebody's saying that the current speaker is breaking up. I'll try to be clear. Hopefully, maybe closer to the microphone. We're going to show you a couple of tables here on the next two slides dealing with the issuance of US dollar covered bonds in the United States in the last few years and the issuance of covered bonds by on the following slide by Canadian banks in March and April of this year. Next slide, please. So I know there's a lot of information on this page and it may be a little bit hard to read. So this is the US dollar issuance of covered bonds from January 2017 through June of this year. You will see about half of the banks on this list are Canadian banks, but there are also a number of German banks, Australian banks, and Scandinavian banks on this list. This is just to give you some indication of the level of activity in the in the issuance of US dollar covered bonds in the US, and the sizes and the coupons on those offerings. Next slide, please. This slide gives you the issuance of covered bonds, not only in the US, but in jurisdictions around the world by Canadian banks in March and April of 2020. You can see from this list that the issuance activity was really quite high. I need to note, however, that over in the column on the far right, you will see the abbreviation BOC for a number of those offerings. These are offerings by a bank of what are called retained covered bonds. So the covered bonds are issued, they are retained by the issuing bank rather than being sold into the marketplace. And they are repoed with this central bank, with the Bank of Canada, so BOC. This is a very recent development in Canada. It was a facility that the central bank put in place as a result of the pandemic. And as you can see, Canadian banks were very quick to take advantage of that opportunity. Nevertheless, they also sold a great many bonds in jurisdictions around the world at a time when liquidity was really at a premium for many banks. Next slide, please. So let's talk for a moment about two legislative developments one, the TLAC registration, the TLAC legislation in Canada, and two, the covered bond directive in Europe. So in 2018, Canada adopted a new resolution regime for banks, and as part of that, it adopted a total losses absorbing capital rule, and it established a bail-in regime. So under the bail-in regime, senior debt of Canadian banks is subject to being converted into equity of the bank in the event of the bank's financial difficulty. The TLAC requirement is phased in, as it's expected to become fully effective next year. And there had been some concern that TLAC issuance would take precedence over the issuance of covered bonds. That hasn't turned out to be the case. Most Canadian banks report that the normal runoff of their senior debt and replacement of that by TLAC eligible debt will occur in the ordinary course and not impact their covered bond issuance. And as you can see by the prior chart, it does not seem to have impacted covered bond issuance. Next slide, please. So in the EU, there has been an adoption of a rule called the Covered Bond Directive, which became effective last year. And it's intended to harmonize covered bond regimes across the European Union. As part of that adoption, the Capital Requirements Directive was amended to provide that preferable capital treatment for banks holding covered bonds would only apply to covered bonds that were issued in compliance with the Covered Bond Directive. Now, the Covered Bond Directive applies only to EU banks. And accordingly, non-EU banks are not eligible, covered bonds of non-EU banks are not eligible for preferential capital treatment under the Capital Requirements Directive, which put them at a disadvantage in the marketplace. In that, if European banks buy Canadian or Australian covered bonds, for example, they must maintain higher capital against that investment than against the same investment for an EU bank. Thus, you're going to see AAA rated Canadian covered bonds not being eligible for preferential capital treatment, whereas covered bonds of a lower rated EU issuer could be.
What we've seen year to date is away from the comments you made vis-a-vis the Canadians in March and April, we've actually seen a pretty meaningful slowdown in covered bond volumes globally. They're down in the sort of low teen double digits overall. In euro and sterling markets, which tend to be the primary markets for issuance of this product, they're down over 30%. And in the US, we're coming in lower year over year. And that's off a pretty sort of quiet year for 2019. We only saw just shy of 12 billion price in 2019. We're just around 8 billion for the year this year. And when you look at that versus a peak in 2012 of 44 billion, we're clearly off the highs there. I think a fair amount of that has to do with the more limited issuer base that have been accessing the U.S. market. Specifically, it's been mostly Canadian banks, Australian banks, and then a handful of UK borrowers as well from Europe. And that I'm speaking specifically to the 144A Reg S market, which we would consider global issuance. Not some issuers do Reg S only transactions, which are for offshore distribution only. I'd say from a tenor perspective, we've seen most of those instruments remaining relatively short dated, and I think that's directly a result of these instruments being one, used as a bit more of a defensive product. So when markets are more volatile, they provide a nice a nice shield from some of that volatility given the secured nature. And a number of borrowers tend to use these, as more short-dated liquidity at the bank versus, as Jerry mentioned, the TLAC build for a number of borrowers who have either TLAC or MREL requirements at the holdco or in senior non-preferred, which tend to be more long-dated instruments in nature in senior format. I'd say the other point that issuers look quite a bit at, and this may also have something to do with the fact you've seen the supply dynamics tick down, and not necessarily only because of the removal or the barriers put up by the lack of SEC availability. It's really been about cost, and you'll see at the bottom of the chart that was just put up on the right there that typically borrowers like to use their collateral for covers when it makes sense and they're getting value for that collateral to slap the AAA rating on there. You don't want to be necessarily giving up that collateral if markets are pricing senior in an attractive fashion as they are today. So there was a point this summer where the covered to senior ratio was north of 90%, meaning that essentially we were able to price senior much closer to those covered levels, and really we're not getting good economics for putting a secured product out there. There have been a lot of instances, by example, last January where that relationship was closer to 50 or low 50%. So you were getting good value to issue with in AAA format. Some other borrowers, while economics are probably the key priority, and again, these borrowers are global borrowers. They're looking across currencies, whether that's euro, sterling, in some cases a dollar for covered bond access. So the economics of the transaction, both on a cross currency basis and measured against senior, are important. But a number of borrowers also want to make sure that they are staying frequent in the market, and if they're updating programs, that they're at least issuing one time or two times a year. So that also plays a factor. And then, as Jerry mentioned, the basis swap as well, and what that looks like, as a number of these institutions are offshore. So if they're swapping it back to their home currency, ensuring that basis swap and where they'd be able to fund this type of product in their home currency makes sense. That's part of the reason as well you've seen as much 3-year and 5-year issuance in dollars is the basis has always been a bit more attractive in the front end, particularly for those swapping back to euros. The other point and final point I'll make is just around the investor base for this product. In US dollars in particular, it tends to be very heavily weighted towards international bank treasuries and SSA buyers. Again, those names tend to have an acute focus on the 3- and 5-year part of the curve. They're buying for HQLA books, and so are very focused on the short end, given the nature of that liquidity portfolio. And maybe just one other point on Jerry's comments on the activity of the Canadian banks in international markets in April and May, excuse me. I think one of the things that we saw in that time period was an enormous amount of liquidity provision from the global central bank community, whether it was TLTRO funding in the Eurozone, a similar facility put in place in the UK, the Fed coming out with a number of backstop liquidity measures for both the CP and the term markets. And Canada, did have a number of those liquidity provisions also put into place. As Jerry mentioned, you saw, an enormous amount of self-issued or internally issued covered bonds that helped to, help those Canadian banks fund some repo operations. Our own parent did north of, I think, 30 billion of funding for self-issued. But I think the other component of this is that the Canadian banks have historically, and if you look back to the global financial crisis, have historically used covereds as a way to get third-party liquidity without having to fall back on some of those government facilities, and did so in this particular bout of volatility as well. So I think they were creative in using both the ability to self-issue securities and then pledge those to the various Bank of Canada facilities, as well as continuing to use that third-party liquidity, which again is part of the reason cupboards are in existence, is to have an additional tool in the arsenal when when crisis hits.
Laura, the Canadian banks in April and March and April were very active in the European covered bond markets at a time when European banks were not quite so active. And I think there was some consternation amongst the European banks that the Canadians were driving the spreads out on covered bonds in a market by being in the market so aggressively at that time, and that it was harmful to the interests of the European banks. How much spread widening did you see from that activity?
Sure. Look, and if you think about the available outlets during that period, I think to compare it again and contrast it, it's not apples for apples, but to compare it to the global financial crisis, there were periods of time in late September 2008 and early 2009 where, without government assistance, and particularly some of the TLGP or government guaranteed issuance, banks simply would not have had an ability to access the market. This was a very, very different crisis whereby institutions still had pretty healthy access to the market, albeit at exaggerated spreads. And I think what's useful in highlighting is, the Canadian banks went to the markets where they were getting the lowest cost to deliver product and the lowest cost to deliver currency. So as a result, you saw a number of euro and sterling transactions, simply because the dollar market was not providing the same level of attractiveness in terms of spread. And then if you compare it to where they would have been able to do something in the senior unsecured market, I mean, you're talking about hundreds of basis points difference. So you probably could have done a 5-year in March, in late March or early April, for any one of the Canadian banks at 350 over treasuries, and the covered market was providing much more attractive pricing at that time. As I mentioned, to the tune of hundreds of basis points. So while yes, there was some consternation that these Canadian banks were crystallizing wider spread points. Again, by comparison against what else was available out there at the time, and as you've seen, a number of those banks were also simultaneously issuing cupboards into their own internally issued systems and then pledging them to the Bank of Canada. So they were marrying the two outlets in a way to sort of bring down their overall cost and not have to crystallize that 350 or 400 over in the unsecured market.
So just a little plug here for covered bonds. It really is a demonstration of the value of covered bonds in providing liquidity to banks in some very difficult times. There was fairly remarkable activity by the Canadian banks. We don't have much time left here. I have 2 sections left to cover, and I'm just going to cover them kind of in a summary fashion. So as I said earlier in the presentation, 2 U.S. banks have in the past issued covered bonds. Washington Mutual began issuing in 2006. Bank of America began issuing in 2007. Between them, I think they offered about $20 billion of covered bonds. These programs were shut down in the midst of the financial crisis in 2008, 2009. And no U.S. bank has issued covered bonds since that time. Those offerings were extremely well received. And as I said, the outcome for investors in the Washington Mutual covered bonds was really illustrative of the value of covered bonds in difficult times. those two, the issuance by those two banks of covered bonds led to the development of a legislative effort in covered bonds starting in 2008, where the U.S. Treasury was promoting covered bonds. And then largely through the efforts of one congressman from New Jersey, starting in 2009, and ultimately in 2011 of a bill before the House of Representatives. This bill was passed, the draft of the bill was passed by a vote of 44-7 in the House committee, which is a remarkable illustration of the bipartisan nature of covered bonds. That even in 2011, it was a fairly partisan Congress. The covered bond bill got very strong support. However, the development of legislation in the United States really has turned on, or will turn on, what ultimately happens with Fannie Mae and Freddie Mac. For U.S. banks, funding through Fannie Mae and Freddie Mac is a preferred alternative for funding mortgage loans. Fannie Mae and Freddie Mac price in the market at prices that independent non-governmental entities simply cannot price at. So Fannie Mae and Freddie Mac are the preferred outlook. And it's only when there's some resolution of their status, and if it turns out that Fannie Mae and Freddie Mac will not provide sufficient funding for banks, that they may turn to other alternatives and may turn to covered bonds. We will see what happens after this next election. There was some quiet indications in 2016 after the prior election that there was a place for covered bonds in housing finance. Excuse me. That did not really develop into anything. And with the split in the Congress in 2018, that all prospects for that, I think, went away. So we look forward to what happens after this next election. In the last few slides here are some elements of what that legislation in 2011 looked like, what the proposed structure was for a U.S. issue. With that, I think we will call an end to the presentation. Thank you, everybody, for joining us. That concludes the presentation.